Hello, I thought I'd do a quick update about an inquest I attended today. I attended the second day of an inquest into the death of a man called Andrew Marber. Andrew died in February 2020. His inquest was started in the summer 2020, but was abandoned due to technical difficulties. It was being held remotely. Today, his mum, Angela, was in court along with some of the witnesses, and then I attended remotely, dialed in on an audio link. So Andrew was 53 when he died in February 2020, right back before COVID. He was clearly much loved by his family and friends, and I wrote a blog post about him a while ago. I'll include a link. And he was into dramatics and theatre, and clearly was a bit of a comedian in his own right, and a founding member of the Freewheelers Theatre and Media Company. Andrew had Noonan syndrome and autism, but as the coroner commented today, that clearly didn't impact on his life and his ability to have a very full and enjoyable life at all. On the 2nd of February 2020, Andrew collapsed at home and was admitted to St Helier Hospital. After many hours in A&E, he was admitted, and the next day a gastroscopy found that he had bleeding ulcers, and they were treated during this initial gastroscopy. And what we then heard in court today was what happened next. Angela kept meticulous notes of the care that Andrew received when he was in hospital, and clearly had a not good experience, I think it's fair to say. And one key matter that the coroner wanted to resolve or explore was whether a failure to identify the fact he'd had a heart attack on the 5th of February, the morning of the 5th of February, and whether it could be said that there was any realistic link between potential failures to identify that heart attack and the ultimate outcome for Andrew. And I'm going to tell you a little bit more about that in the next video, because I'm about to run out of time. So the coroner heard from a number of witnesses and an expert who she had instructed to have a look at the care and treatment that Andrew received. And the cause of death that she decided on, I'm just going to read from a note so I don't get it wrong, was 1A, multi-organ failure as a consequence of 1B, myocardial infarction, heart attack, and an upper gastrointestinal bleed due to peptic ulcers. And there was a bit of discussion about this cause of death. There were 4 different options available to her, all that focused round about there, but different questions as to what type of heart attack and whether it was heart failure or multi-organ failure that caused his death, whether pneumonia should feature, and whether Noonan syndrome should feature, which had been included at part 2 on his original death certificate. Angela Marber, Andrew's mum, didn't think it was relevant, and the expert agreed with her, as did the intensivist who gave evidence, and the coroner found that Noonan's didn't play any part in Andrew's death, so it won't feature on his death certificate. So that doesn't feature on part 2. And the coroner summed up what the independent expert said when she was summing up her evidence, and she said he didn't really see anything terribly different to the treating clinicians. He was clear it didn't matter which type of myocardial infarction it was. Unfortunately, once the myocardial infarction happened, heart attack, the die was cast and no treatment could be given because they were all contraindicated. And this is the nub of it, really, in terms of the cause of death for Andrew. It doesn't really necessarily speak to some of Angela's concerns about the quality of the treatment he received, or indeed her experience trying to support him in hospital. More in the next video. So Andrew had been admitted to hospital due to this upper GI bleed. He'd had an ulcer that was bleeding. And because they needed to get the bleed under control, and to stop a bleeding, you want the bleed to clot, I think. I'm not medical. That's how I understand it anyway. But the problem was that when Andrew suffered the heart attack, whichever type of heart attack it was, the actual treatment options available to the treating team were incredibly narrow. In fact, there weren't really any options available to them. And various witnesses explained this. And I think, this is my understanding, I think problem was the treatment for a heart attack is to be given either antiplatelet drugs or blood thinning agents in order to do a procedure to add a stent or to deal with a blockage. Basically, you have to thin the blood to deal with the blockage, or you have to you have to be given beta blockers or ACE inhibitors, which lower your blood pressure and slow your heart down. Of course, all of this was too risky for Andrew because he had this other bleed. He had this gastrointestinal bleed. So giving him any treatment to thin his blood or to slow his heart when he was already bleeding and his blood pressure was already dropping would have just been too risky, and he risked having an absolutely catastrophic bleed and bleeding out if they'd treated it. So they all agreed, and the expert agreed, and he kind of talked about his practice where he's a doctor, that it's a really tricky, very difficult situation if somebody comes in with these two effectively competing diagnoses. So the phrase used was that the die was cast, and there was no active treatment. Andrew could be made comfortable, which he was, but there was no active treatment available. In the words of the coroner, Andrew's heart had a significant insult and didn't recover. And listening today, I was on the audio link listening to Angela, who was unrepresented. She was representing herself in court. I can't help but think that her heart would have suffered a similar insult, at least in the philosophical sense, and is unlikely truly to recover. I just do not see how it is fit for practice that family members are expected to represent themselves in court. The coroner was firm but fair, I think. She was happy to reframe Angela's questions into questions that could be asked of the witnesses. But I just got a distinct sense that Angela wasn't feeling heard, or perhaps I don't know, I've not spoken to her yet, but perhaps she didn't feel like she got the right questions answered or her questions across well enough. And of course, for the coroner, there's a fine line between nobody is allowed to give evidence when asking a question, but that leads to difficulties if you're not trained in the law and you don't understand how to ask questions to get the best answers. So, yeah, I'm not sure how Angela would have found that process. But I just think bereaved families should be entitled to legal representation in the same way that the trust had a legal representative there who was trained in the law. And he was able to represent the trust's position and the witnesses and frame his questions in a way that probably got him the answers that he needed. So yeah, that's that, I suppose. Yeah, insulted hearts.